Good morning, viewers. Welcome to the IAS initiative brought to you by Classic KS and IAS Study Circle. I am your educator and faculty, Amoghavarsha R. Today we will be discussing a very important and a very perennial current affairs topic known as delay in Supreme Court judgments or pendency of cases in the judiciary or the Supreme Court. This is not a very recent phenomena. It is been in news for a very long period of time, but it is a very important topic, as in UPSC mains in GS paper 2 every year you can expect a question from the judiciary. Even this topic is very important for your KPSC mains examinations. So let us understand in detail, in very depth, the issue of the Supreme Court delay in judgments or the pendency of cases in Supreme Court. So before we dive into the topic, let us first understand the concept of justice. What is justice? Justice is nothing but the upholding, the phenomena. Justice is a phenomena where the rule of law or the law of the land is upheld or upheld. Justice can happen only when the rule of law is same for each and every citizens of the country. There is a stratification, there is a social stratification in the Indian society, we all know that, but for justice to occur, everyone in the society, from the President of India to the most common man, the justice should be delivered immediately, instantly and effectively. This is justice. Justice should not only be delivered, justice should not only be done, but it should be seen as being done. People should realize that justice is really being done. People will realize this justice is really being done when it happens without any delay. It should be instantaneous. So let us understand this topic in detail. Let us understand why there have been instances of pendency of cases in Supreme Court and what are the effects of it. What are the then also let us try to understand how can we change this scenario, how can we reduce the pendency of cases in the Supreme Court. So let us dive into this topic. So as we all know, if justice is delayed, justice is denied. So justice to not be denied, justice shouldn't be delayed. There should not be any pendency of cases in the judiciary. So the pendency of cases in the judiciary has increased over the period of time. Over the years, the pendency, the cases in the courts have increased. And it is very important to know this fact that most of the pending cases are in the subordinate courts. That is 87% of all the pending cases are in the subordinate courts. Let us look at a graph here. Let us compare. This graph signifies that there have been increasing pendency of cases in the judiciary. Take example, pendency of cases in Supreme Court. It has increased. It is in thousands. So at present, if we take the 2019 data, over 60,000 cases are pending in the Supreme Court. If we take the case of High Courts, 44 lakh cases are pending in the High Courts. In the subordinate courts, it is in crores, 3.1 crore cases are pending, and these pending courses, pendency of courses has increased over the decade. So there have been increase in the pendency of cases. That being said, let us try to understand one of the important reason, and let us look at the result of this pendency of courses. As the pendency of cases has been increased, the under trials means the people who are not yet convicted by the courts but waiting for the trial to even begin, the investigation to begin. These under trials in prisons are double that of the convicts. Convicts are the people, the criminals convicted by the courts. So the number of under trials is greater than the number of convicts. As you can see in this picture, this graph represents the, it compares under trials versus the convicts in various states. This blue graph represents the number of under trials. As you can see, the percentage of under trials is greater than percentage of convicts. This is the direct results of pendency of cases. one of the important reasons for pendency of cases in the judiciary is vacancies. The vacancies of judges, in the high courts and supreme courts are quite high. So in the high courts, you can see the sanction strength versus the actual strength. The actual strength is very much lesser than the sanction strength. That is, the number of vacancies, the recruitment is inordinately delayed. The recruitment is very less. This is one of the reasons which will affect the disposal of the cases. It is quite it's a common sense matter that if the number of judges are less, the disposal of the cases will also be slower. So vacancies is one of the reasons for pendency of the cases in the judiciary. Now let us understand where the judiciary stands in the structure of the government. You might already be knowing that the government structure has three wings or three pillars. There are three pillars of government in India. The first one is legislative pillar or the legislative wing. The legislative wing makes the laws. They makes the laws or they write the laws. The legislative wing makes the law, whereas the executive wing of the government implements the law. The executive wing of the government implement the law, whereas the judiciary wing interprets the laws. The laws made by the legislative and the implemented by the executive is interpreted by the judiciary, whether they stand the test of the constitution or not. This is the government structure. So judiciary is one of the important wing of the government structure in India. Moving forward, this is the hierarchy of Supreme Court in India. This is the hierarchy of courts in India. At the apex lies the Supreme Court, then comes the High Court, then comes the subordinate courts. This is the structure of the judiciary in India. So let us understand some of the facts of the Supreme Court in India. Supreme Court came to existence on 26th January 1950. It came to existence on 26th January 1950, the same day when our constitution was enforced. So you also know that where is the location of the Supreme Court? It is in New Delhi. Our Supreme Court is the constitutional body. Constitutional body means the Supreme Court has been mentioned in the Constitution, and it lies in the chapter 5. It is mentioned, the Supreme Court of India is mentioned in the chapter 5 of the Indian Constitution from articles 124 to 147. We are looking at the facts of the Supreme Court of India. So Chief Justice of India, the Chief Justice of India is the head of the Supreme Court in India, and there are many other justices, there are many other judges as well. So as of now, the maximum number of judges in the Supreme Court, the maximum strength is 34 judges. That is 33 plus 1. 33 Supreme Court judges plus 1 Chief Justice of India. So the Supreme Court of India is also called as the appellate court. That is, the litigants who are not satisfied with the judgments given by the subordinate courts and the high courts take their cases further to the Supreme Court. So the Supreme Court of India hears the appeals of the litigants. So Supreme Court of India is also called as the appellate court. Supreme Court also safeguards the fundamental rights. It safeguards the fundamental rights given in the Part 3 of the Indian Constitution. So if you have been violated of your fundamental rights, you can use Article 32 of the Indian Constitution. That is, you can knock on the doors of the Supreme Court using the writ petitions. So Supreme Court of India safeguards the fundamental rights of the citizens as well. Also, Supreme Courts of India hears the cases where there have been disputes between the governments. For instance, if there is a dispute between the central government and the state government, the Supreme Court of India hears such cases as well. Further, Supreme Court of India is also called as advisory court. It means when President of India can ask advice from the Supreme Court of India, and Supreme Court may give advice to the President of India. So Chief Justice of India and other judges. So the tenure of the judges of these judges and the Chief Justice of the Supreme Court of India is 65 years. They will retire after they reach the age of 65 years, whereas the tenure for High Court judges is 62 years. So these were some of the facts about the Supreme Court of India. Now let us understand the status of delay. Let us understand some of the facts of the delays in Supreme Court, delays in cases in the Supreme Court. There are about 3 crore cases pending before all levels of the courts in India. This leads to a situation known as justice delayed is justice denied. So out of around 60,000 cases are been pending in Supreme Court of India. Around 45 lakh cases are been pending in the High Courts of India. This is the status of delay or pendency of cases in the Indian judiciary. So now let us understand the various reasons for delays in the cases or the pendency of cases in India. Inordinate delay in filling up the vacancies. There are around 6,000 posts. 6,000 posts are lying empty in the subordinate courts. As there are less number of judges, the cases that the amount taken to dispose the cases will also obviously increase. It leads to a phenomenon called as poor judges to population ratio. Judges to population ratio means what is the number of judges in proportion to the population. Today, India has only 20 judges per 10 lakh population. That is, for every 10 lakh people in India, there are only 20 judges. Only 20 judges for 10 lakh people in India. So earlier, the Law Commission of India had recommended that there should be at least 50 judges per 10 lakh people. There should be at least 50 judges per 10 lakh people. This is one of the important reasons. That is, vacancies. The number of vacancies is very high. This is one of the reasons for pendency of cases. Moving forward, let us look at another reason: frequent adjournments. Frequent adjournments, that is postponement of the cases. You might have seen this phenomena in movies and TV and all, where the judges will postpone the cases. They will say, come next month, let us postpone the case to the next month. It is also called, this phenomena is also called as tariq pe tariq. So this frequent adjournments is also delaying the timeline of the cases. So there is a procedure that there should be only 3 adjournments. There should be only 3 postponement per case, which is obviously not being followed. This is another important reason for pendency of cases. In addition to judicial shortages, courts are underfunded. The budgetary allocation to the functioning of the judiciary is quite less. That is why they are underfunded. So also the working days. The Supreme Court works on an average of 188 days, but according to the rule, they have to work for 225 days. So they are working less. They are working only 188 days out of 225 days. This is also leading to the pendency of the cases. So in order for the Supreme Court to dispose of the cases very quickly, the investigation have to be very efficient. Only if the police investigation is quite efficient, the cases can be disposed very quickly. But the thing is, Indian police is lacking forensic tools. As they are lacking forensic tools and modern and scientific tools, the length of the investigation process is taking quite a lot of time. This is also leading to delay in cases or pendency in cases. Also, the people of India, thanks to the social media and the improved education system, are quite aware of their rights today. As they are quite aware of their rights today, whenever the rights of the people of India is violated, they will obviously knock on the doors of the judiciary to get the justice done. So, as people are more aware of their rights today, they are approaching the courts more frequently in case of any violation. This has also increased the number of pendency of cases in the judiciary. So what is the impact of the judicial pendency? As our Vice President of India, Mr. Venkaiah Naidu ji, had said that Denial of timely justice amounts to denial of justice itself. When justice itself is denied in the society, there will be chaos in the society. So this is the first impact. And timely disposal of cases is essential to maintain the rule of law. If rule of law is not maintained in the society, there will be less harmony in the society and the crimes will increase in the society. And also, it is very important to know that under Article 21, in Part 3, Article 21 is a fundamental right. According to Article 21, which is a right to life and liberty, speedy trial is also a fundamental right. So, speedy trial, speedy access to justice is a fundamental right of the citizens of India. When this judicial pendency increases, the people of India are deprived of their fundamental rights. So these were some of the impacts of pendency of cases. Now let us see what is the effects. It affects the human rights also. The pendency of cases affects the human rights also. We just now saw a few minutes ago that number of under trials are more than the number of convicts. So the under trials, as they have not yet been convicted of a crime, still they are spending their precious time in the jails. Instead of enjoying their life, they are spending their precious lives in the prison. So their human rights have been violated, grossly violated. This has led to overcrowding of the prisons, overcrowding of the under trials in the prisons. So their human rights are being violated. It also, the pendency of cases also impacts the Indian economy. According to a study, the judicial delays cost 1.5% of the India's GDP annually, which is quite a heavy number. It is a very big, huge number. So there is economic cost of judicial pendency as well. Also, when there is delay in giving justice to litigants, the criminal entities in this society think that we can go scot-free. We won't be convicted for a very long period of time. So there will be less fear of the law amongst the criminals. So what are the solutions? There should be solution, right? So what are the, let us discuss the solution. As we saw, out of the 225 sanctioned days, the judiciary works only 188 days. This should increase the working days in the higher judiciary. And professional court managers should be appointed. As in the MNCs, there will be professional managers who manages the organization. Similarly, the Supreme Court or the higher judiciary should hire someone known as professional court managers to efficiently handle the cases. And there is also one constitutional provision in our constitution itself that Supreme Court of India can use the retired judges to look after the cases, to go after the cases. Similarly, in the High Court also, there is a provision of taking the service of the retired and acting judges to dispose of the cases. It should be utilized frequently. Reducing disposal times of pending cases. There should be some time specification. There should be a strict time specification that certain trials should be completed in some in the specified time period. For instance, in criminal cases, there should be a law that it should be disposed of within 1 year, and simple civil cases should be disposed of within 3 months. So there should be a specified time period for the cases. Then the pendency might be reduced. Also, we discussed that there is already a law, that there is already a regulation that there cannot be more than 3 adjournments in a particular case. So it should be strictly followed. It should be strictly enforced. Also, the physical infrastructure of the courts must be improved. This can only be done by higher budgetary allocation. The government should allocate an higher budget for the functioning of the judiciary. Utilization of information technology can also greatly help in reducing the pendency of cases. Instead of giving notices to the litigants by manually or by hand, the notices to the litigants can be sent through mobile applications. Also, there is virtual or e-courts in many parts of the country, and this was very much successful in the Delhi. This should be implemented in various other courts. The implementation of e-courts should be increased in the courts all across the country. Even during the COVID times, courts are functioning through e-courts itself, through virtual courts itself. This phenomena should be improved greatly. The number of clerks must be increased. Each judge will be given some clerks to help them in disposing of the cases, in functioning in case management. So the clerks given to the judges in India are quite less. The clerks should be increased to filter out the appeals. That is, these clerks can help the judge in writing memos, drafting the decision, which is the norms in other countries. In other countries, the amount of clerks to each judges is more when compared to India. For instance, in United States and Africa, usually each judge will be given to something around 4 to 6 clerks, whereas in India it is only 1 to 2 clerks. So this phenomena should be changed, and the clerks given to the Supreme Court, to the higher judiciary judges, should be increased. So this was the topic about dependency of cases in Supreme Court of India. We have seen it from multiple dimensions. We understood the phenomena of justice is delayed justice, is justice denied in itself. We understood the reasons for the causes of pendency of cases. We also understood what should be done to tackle the pendency of cases in the higher judiciary in India. I hope this session was very fruitful. We'll meet in the next session. Thank you, viewers.